May I request Mr. Anuj Bugga, the moderator, to please have his team up front and then have the caller mics. Mr. Anuj Bugga, Mr. Andrew Dale, Mr. Shankh Sengupta, Mr. Neville Gandhi, and Dr. Brinda Jagirdar.
All right. Good morning, good afternoon, everybody. It's a pleasure to be here, and firstly, thanks to IDEX Legal for having this conference and putting in place such a lovely panel to discuss this very important topic of tackling economic crimes internally, a topic that I'm sure worries all of us sitting in this room, but we don't speak too much about it. We are joined today by a common concern of instances of economic crimes being perpetrated by people who are within our own firms, insiders, and so on and so forth, for collective profiteering or for their own benefits. This is not just a reputational risk. It goes much beyond that with globalization of the world as it is happening. Now, we put in place a very esteemed panel here, and thanks to IDEX Legal for that. And I'd like to start with the introduction of this very esteemed and diverse panel. Andrew Dale is a partner in Robson Gray, Hong Kong office. He's a member of the firm's business and securities litigation practice, has more than a decade of experience in Hong Kong, representing US-based and international corporations in litigations, arbitrations, corporate investigations, including relating to India. Shankh Sengupta is a partner in the disputes resolution practice of Trilegal and specializes in commercial disputes and white-collar crimes. Shankh represents Indian and multinational clients in corporate and commercial disputes and looks into shareholder disputes and internal investigations relating to anti-corruption and bribery issues. Shankh has represented sovereign funds and defense equipment suppliers in headline matters involving public procurement, mismanagement of investor funds, and matters involving kickbacks and facilitative payments. Going on to Neville. Neville K. Gandhi is the Regional Compliance Officer of Siemens India since June 2010 and is responsible for the compliance function for operations in South Asia. As the compliance officer in a complex and high-risk environment, Neville's responsibility lie in setting up of correct compliance tone and its adherence, playing the role of a business enabler without diluting the demands of compliant business processes, providing the necessary assurance to the local management. Neville's work requirements also necessitate interacting with external stakeholders and propagating Siemens' way of conducting clean business through collective actions. And of course, last but not least, Brinda, will take a while if I have to cover her distinguished career, but just a highlight of that. Brinda Jagirdar is an independent consulting economist specializing in Indian economy and financial intermediation. She's an independent director on boards of several companies. Brinda is an advisor to several industry bodies, including Research Advisory Committee of the Indian Institute of Banking and Finance. Brinda retired as a general manager and chief economist of State Bank of India. As part of the bank's top management team, Brinda worked at SBI involving tracking developments in the Indian and global economy and analyzing implications for policy and participating in the bank's Asset Liability Committee and Central Management Committee. Brinda was associated with the Raghuram Rajan Committee on Financial Sectors Reforms in India, was a member of the Planning Commission's subgroup on household sector savings for the 12th five-year plan, and a member of the Ministry of Finance group of deepening India's household financial savings. It took a while to cover, but I had to do justice to each of the panelists. Just a disclaimer before we get onto the topic. This is a sensitive topic, and although a critical one as well. The views that will be expressed by the panelists are their own, based on their wide experience and industry expertise. So, it's the personal views. Some housekeeping points. If you have any questions during the course, I would request that they can be left till the panelists have given their views, and we have covered the topic fully. And we'll take the last 10-15 minutes for question and answers. So coming on to the first topic, and that is, we'll start with the what are the economic crimes, what are the type of economic crimes and the seriousness that companies have faced in the last 2 to 3 years? What troubles companies the most, and what do the panelists think are going to be the trend in this, or what do they foresee are going to be the economic crimes in the future? So I'll open the floor, and Andy to start with you.
Thank you, Anuj. I think there are a number of different topics and areas, and I think most of them will come as no surprise to people in this room. Bribery, corruption is clearly up there. More recently, anti-money laundering, sanctions. These issues are coming more and more to the fore. Now, whether that will change now there has been a change in administration in the United States, it still remains to be seen. But the indications are at the moment that these issues have been problems for the last 2 or 3 years and beyond, and will continue to be so. And particularly as in India, the huge amount of investment that is being made in India and hopefully will continue to be made. I think looking a little bit more to the future, and we were discussing this yesterday, cybercrime is something that is becoming of increasing concern to our clients in a number of different aspects. It touches upon all of us, whether we're law firms, whether we're companies, and it touches us not only in our commercial capacity, but also as private citizens as well. Those are the key issues, I think.
Thanks, Andy. Very insightful. Brinda, how about your thoughts, please?
I'd just like to add on to what Andy said. Besides all, right now, I think it's economic crime, the white-collar crime that is growing the fastest, and I think that is also going to be the most important as we go forward. Besides these, which Andrew has listed, I would like to add there's something insider trading. That again, we had the Magellan Fund case and the repercussions and fallout. And there is mis-selling and collusion. Mis-selling, the global financial crisis clearly demonstrated that there was a lot of mis-selling going on, and I think the consumers were really hurt, and that really brought down the whole sector like a pack of cards. And collusion, recently the LIBOR fixing case, for example. So there are so many instances where the economic crime, because this is human nature, I suppose. So every place wherever some loopholes can be found, I think that's where we will need to be careful. And another area where we could find economic crime is also the loopholes that are there in international treaties. So somebody would fix up, like say, shell companies or valuation or things like this. So that's where there is scope for crime going forward.
Thanks, Brinda. Shankh, over to you.
Yeah, I sort of echo the thoughts of Brinda and Andrew, but let me just try and trace out this transition. About 5 to 7 years ago, one used to see in terms of white collar or economic crime, so to say, was kickbacks from procurement people, from external vendors to procurement people in companies, small instances of bribing government officials. That has sort of now transitioned into situations where large-scale fraud and large-scale corruptions have been sort of caught, and therefore a heightened monitoring of those crimes. We've seen cancellation of 2G licenses, which has been one of the biggest, and we were talking about billions of dollars of investment, not only from within India but from outside of India. Despite mobile operators being in the business already, the courts didn't stop from cancelling those licenses. That I think is a watershed moment in the Indian judiciary's appetite in sort of taking on and running on with white collar offences. Subsequently, we've seen Augusta Westland scam, the Embraer scam. I think as years go by, the level and the kind of crimes, white collar crimes in special, have been getting more and more interesting. Offenders are getting more savvier. As Andrew pointed out, the new age white collar crime is indeed cybercrime, and I end up dealing with a lot of cases of data theft, especially with India being a hub for call centers, which actually deal with raw personal data of persons outside the country, including credit card information and personal information. And while India sort of is gearing up to get infrastructure to tackle all of this, but one can see establishment of specialized agencies such as the SFIO, you have the cyber cell, you have the economic offences wing. A straight example is a few years ago CBI was operating from one floor in a old dilapidated building in central Delhi. Now CBI has a full blown building which only shows heightened prosecution and investigation in all white collar and financial crimes.
Thanks, Shankh. Neville?
Just to draw a common thread through all three, and if I need to add, look at the Transparency International's rating of India. Its rating still as a high-risk country. We have marginally improved from 38 to 40, which is not much of an improvement, but still in the right direction. But it still shows a heightened source of an awareness that there is corruption. And as Shankh said, it is now not just individual low-level corruption, but it is, I would say, dominated by high-level corruption and very savvy and politically savvy people also.
Yeah.
So, all in all, the concept of corruption has changed. The drive has changed. The goals have also changed from just my end to look at big tickets.
Right.
So it's there.
That's very insightful. Now, related to this, I'll just bring out what the National Crime Records Bureau of 2015 has to say. In the last decade or so, the economic crime rate in India has doubled, right? So that brings me to the next topic of our discussion, and that is, what do you see is the response of a domestic business vis-a-vis a multinational business? How do they differ? Because the world is getting globalized more and more, and even before companies respond, the damage has actually moved out of the international boundaries, and how do you sort of control it, right? So, I'll start with Shankh for you. You have advised domestic and multinational firms in internal investigations. What has your experience been with Indian companies responding to internal crises? Do GCs come up to you and talk about comprehensive investigations of instances or of economic crime?
Yeah, so again, it's a constantly and rapidly changing environment when we look at these issues. The tendency of Indian companies is to be defensive and protective in a manner, and that essentially stems from the difference in the jurisprudence of economic crimes in India and especially in the West. For example, if you look under the FCPA or the UKBA, which are essentially acts, legislations in the United States and respectively in the UK, they tend to have an extraterritorial jurisdiction over crimes committed by their officers outside the country. Now, these legislations provide for what they call as deferred prosecution agreements and non-prosecution agreements. Typically in two lines, it is essentially if somebody is caught of unethical and corrupt practices, a company can go across to the regulator, the Department of Justice or the SEC, for example, and say that, well, look here, there's a default, there's an offense, and we plead guilty. We have these remedial steps, and please defer my prosecution or do not prosecution. I have the following steps which I have undertaken. Regulators in the West have taken this, and it's a stated policy of the government, and they've taken this and have let companies go on doing their business. As against that, in India, you don't have the concept anything like a non-prosecution agreement or a deferred prosecution agreement, or even technically what we often call as plea bargaining. So typically how lawyers tend to advise in different jurisdictions, especially in India, is that you have to start with a defense. Otherwise, essentially, if you're admitting to a crime, admitting to an economic offense, you're essentially telling the government or the prosecutors in India that here, look here, I raise my hand, I am guilty, I am lying down to take whatever punishment the government or the courts have to offer. Now, this is essentially in conflict when it comes to foreign companies operating in India. The Indian GC will often come around and say, well, you know, and I've had real experiences where the Indian GC says, well, my global GC is actually going ahead to do a non-prosecution agreement, and he wants to name the CFO in India and the sales manager and the line manager in India, and my mandate from my managing director in India is to actually salvage the situation and try and protect it. Now, you have a document outside the country where you are essentially admitting to guilt, but in India, you have a situation where you want to actually defend or even much far from admitting that guilt. So, the basic premise, while was different, defense, admission, it somehow is now getting merged, especially within MNCs. And I had the chance to speak to the additional Attorney General from the criminal division of the Department of Justice in US. I did put him this question. I said, you know, what do you do? Here you have an American company who wants to follow your law, and the American company's Indian subsidiary wants to follow the Indian law. Do you actually take into account when you look at DPAs and NPAs that the declarations or the admissions are fused in a manner that you don't prejudice the subsidiary or individuals in a subsidiary for in lieu of not punishing the American company? His answer was simple. He said, we understand that and we are dealing with these situations, but unfortunately that's the law in the US. We want complete disclosure and we want names, and we understand the Indian law is different. I don't have an answer, but that's the inconsistency we are dealing with. But going forward, the Indian government has tabled a legislation which is similar to the FCPA. I am hoping that we have a similar system of DPAs and NPAs at some stage, which will actually synergize all these efforts, especially when it comes to MNCs.
That's a very insightful legal perspective, and continuing with that, Andy, what are your thoughts on the multinational versus domestic responses based on your expertise and experience? If the culprit is internal, what are the avenues available for recourse, both internationally and in India?
Sure. So I agree very much with what Shankh just said. I don't think necessarily it's a clear delineation between domestic and multinational. I think there are various different drivers. I think the enforcement environment, particularly which industry you're talking about, the finance industry in whichever country, including India, clearly where there are greater regulatory, both legislation, rules and enforcement of those rules, then you're going to tend to see more compliance related issues. Also, related to what was just said, in respect of the enforcement, are the regulators looking at individuals? Are they looking at corporates? That also impacts from a global perspective, because how you react to a regulator locally can directly impact how you interact with the regulator globally. The impact of privilege and how that works, both in-house and also as between different jurisdictions and the different rules which apply. I think that very much impacts people's approach. Just a very basic point of how big an organization is, they are almost more likely to have more sophisticated tools, they're going to have more resources, and therefore may well be able to put more pressure to bear on avoiding these types of issues. I think one of the key issues, and this I think goes over whether you're domestic, multinational, whatever industry, is culture. And that's not a culture in respect of jurisdiction, it's the culture within your company. And the approach to these sorts of issues, both in respect of compliance, but also the reaction to it. And I know we're going to talk a little bit more about that later. So those are really the delineations, I think. But I think as there is more investment into a country, we've seen it in China, for example, even Chinese companies who, years ago would look at you very blankly relating to FCPA and sanctions and all these sorts of issues, now are actually very sophisticated because they are looking to external markets, they're also looking for external investment, and they're also looking for external partners. And so that is part of the process.
So after listening to the law firm's perspective, the question comes to my mind: do the lack of enforcement of laws in India in this regard, or complexities of the laws, it tends to make the management at times brush certain issues under the carpet?
So that would have been somewhat the case about, let's say, 5 years ago. But now with, as Andrew rightly said, every Indian company is looking at some stage investment from outside, who are typically need to be compliant with FCPA, UKB and such legislations. So therefore, in an effort to be viable and lucrative as an investee, the appetite for shielding an offense or an economic crime has gone away or has substantially reduced. So that's the big change.
That's a very interesting point. Very interesting.
In fact, if you see, and a lot of the M&A lawyers here would know, increasingly we see a huge amount of stress on or importance on FCPA diligence, right? This was a concept which was very loosely understood many years ago, but now most international investments, be it PE, be it strategic, are preceded by a very, very robust FCPA diligence, which is simply an indicator of changing mindsets.
Right. Any views on that, Andy?
Totally agree. I mean, you've seen it in the United States when the FCPA and the lifespan of the FCPA, when it was starting to be enforced, how it's been enforced. We've seen the same in the United Kingdom through the Bribery Act. We've seen the same in China, and how corruption has really been at the forefront of the regime. And therefore, when you see pressure being exerted by regulators, it gets people's attention. When people start going to prison, or perhaps even worse, it gets people's minds working.
Thanks. So Neville, does occurrence of one economic crime lead organizations to become proactive and build or adapt their defenses? What are some of these measures you can talk about? And in your view, as a senior management and handling the compliance function, and your view of the industry, are multinationals more responsive vis-a-vis domestic companies, or the gap is getting narrower? By the way,
the gap is getting narrower. And I would like to distinguish in Indian companies, those which are promoter-driven companies and those which are Indian multinationals seeking business abroad. So those companies which are seeking business abroad, as Shankh said, they are trying to put in a very robust compliance program in place because of the due diligence requirements for doing business abroad, as well as they have also realized that it doesn't make sense to hide under the carpet. You need to bring things up on the table to act as a deterrence for future such actions. Multinationals per se, because of the regulations in their countries, have a more robust compliance system. Doesn't mean that they didn't ever have a compliance issue. For instance, Siemens per se, we had a major compliance blow up, but we evolved and we now have a robust compliance system which is comparable with some of the best in the world. And this is a trend happening now in Indian companies also. Large corporates are seeking help to strengthen and augment their compliance controls, and they are trying and looking at FCPA requirements also. Even if FCPA is not applicable to them fully, but they're trying to imbibe some of the good topics out of it to strengthen their control requirements. So the mechanism is working. The gap is narrowing.
Okay, that's finally to you, the board perspective. Do you see the responses of Indian companies or even multinational companies in India, because the laws are a little different, their responses vis-a-vis what we have with the multinational companies who have a very, very, I would say, mature and advanced response mechanism.
As you rightly said, the 2013 Companies Act has made it very clear that there's now no place to hide. The board is very, very is responsible for everything that goes through the board process, and so the boards are really looking much more closely at things which were taken for granted earlier. Before that, Anuj, I think you said something very interesting. You said that economic crime is growing very fast. This growth is also tied somewhere with the GDP growth. It took 60 years for us to reach, after independence, to reach 1 trillion in GDP in 2008. And now in 2015, we've become 2 trillion. And we became 2 trillion, and now we have overtaken at 2.3 trillion, we have overtaken UK's GDP. So the GDP is growing very fast, and somewhere it is also related to economic crime, which is growing very fast. So how we deal with it, those instruments, those processes, those facilitators also need to change. One of the panelists, I think it was Shankh or Neville, you talked about reputation. There was a time when with reputation you could get away. For example, there was this anecdote about a person who wanted to go and buy a very big car. I won't name the company because it's the legal, all luminaries over here. So he went and bought this car, and then it went, but it's moved about, say, 2 miles, and it stopped. He was very shocked. He said, this is a high-end, big company model. How can it happen? So he rang up, and these people came running. And they saw that. They said, sir, but there's no petrol in it. So he said, but how did it run so far? He said, it ran on its reputation. So that can now only go up to a point and no more. We need to have very, very strong systems, control, internal systems to make sure. So therefore, the board is now very closely aligned with what is happening internally within the company. There are strict internal compliances, strict audit, statutory audit, internal audit, risk audit. So there are a huge number of committees, whistleblower. So all this, through this, the board has to, now it doesn't have any choice. It needs to know very closely what is happening within the company. Remember, the board meets only about, say, 3-4 times a year, 4-5 times a year. But at the same time, it needs to have those processes in place by which its ears are very close to the ground.
No, that's a very interesting point brought out by you, Brinda. And to give another analogy to it is, I was speaking to somebody and said, the non-performing assets percentage of India is alarming, and he said that that's also a positive signal that there's a lot of business happening, right? So you can take it in a positive sense as well. But what you brought out, and that brings out to our next point of discussion is, we have, today companies have internal audit functions, compliance professionals, whistleblower hotlines, yet these crimes continue to haunt the corporate world. So what are the companies doing internally to prevent economic crimes? What are these motives for internal wrongdoings, and what are regulators expecting, right? So let's please talk about this point, and I'll start with Neville. In your opinion and experience, do you feel companies are doing enough to prevent internal crimes, and how can GC's compliance align with business?
Keep an Indian promoted company lucrative for foreign investment, they want to have these robust compliance programs, training programs, so that once an M&A is being proposed, one needs to know that, okay, there will be a robust FCPA diligence on which I have to fare very well, otherwise that's a big red flag and the investment won't go through. So I think it's changed a huge amount, and I think there's a sense of alignment to the global intolerance to corruption.
Anuj, if I may just add
please.
Exactly what, that for the first time ever now, the State Bank of India has a chief ethics officer, and I think this is the first in the Indian financial services sector also. So the focus on ethics is now really, which is what is going to help control this economic crime, because audit and everything else is post facto. All this happens, but then crime is committed not by machines and ledgers, but it is committed by the humans. So therefore, I think it's very important to instill this culture of ethics in the whole organization right through. So from a system of training, from a system of reaching out, and not just through fear, but making it very clear that this is the only way now to do business.
Oh, that's a valid point.
Yeah, and just to add to that, I think you make a brilliant point. Initially, we, as a law firm, we would get our clients to reach out to us that, can you recommend a general counsel? Can you recommend an assistant general counsel? More and more, and I'm sure you'll also agree, clients reach out to us asking for references for compliance counsel, ethics counsel, which is clearly a new development. And that's, I think, that's the reaction, or that's the action of stakeholders to be prepared to take on these issues.
Anuj, can I just pick up on
Yeah,
a couple
sure.
of points? Just on the regulators side, the DOJ, the SFO, and other organizations, they've always put out fairly recently guidelines. The DOJ very recently put together quite a short but very succinct and quite powerful set of guidance, which is available on their website. And it's not applicable equally across organizations, but it's in a form that's understandable and perhaps will resonate with GCs and others within the audience. Secondly, that also emphasizes the tone at the top that we've talked about, but there are two aspects to that. First of all, there is no substitute, and this really picks up on something that Brinda mentioned. It's people walking the halls and top management speaking to people, understanding what their pressures are on the ground. It's all very well having a very nice compliance system that's been put at great expense from law firms, etc. But if it's not practically applicable to the individual on the coalface, on the ground, it's never going to work. And then finally, there is a real conversation happening now. And if anyone else has this on their LinkedIn feed, every other conversation at the moment around bribery and corruption, for example, is about the intersection between incentives and sales and bonus and awards,
Right.
and how that interacts with compliance.
Right.
And how compliance and sales can work together, but how also that there is this balance that is very difficult to strike, that companies obviously need to make money, individuals want to do well for the company, but have to do it in a compliant way. And there is a real discussion ongoing at the moment. It is constant. And using actually sometimes incentivization of compliance, calling out good examples of compliance, making examples of people who have really done well within compliance, not just talking about the bad actors, but the good actors, and again, creating that message.
So related to that, Andy, you've published articles on how ensuring compliance requires an active balancing of business pressure with corporate ethics. How do companies go about achieving this balance in an increased era of competition and price wars? Your views on that?
There has to be a conversation. There has to be a discussion between sales, for example, and compliance. There has to be an understanding of what pressures people face, and there has to be teamwork in order to make progress with an organization. Obviously, people have different resources available to put compliance systems in place, but I think very often it's the simple things that actually achieve the greatest results. Talking to people, thinking of organizations, of individuals as people, and understanding the pressures that they face.
We haven't actually talked about what regulators want. What is the regulators' view, and what are the regulators doing? So is the Sarbanes-Oxley or the Frank-Dodd Act the way to go to fight economic crime? So your views on opening this to the panel.
Usually these types of legislation are reaction to big scandals. I think sometimes they're helpful. I think people do query whether, for example, the bounty that's available under Dodd-Frank, whether that's the appropriate motivation for people to comply or whistleblow externally, with vast amounts of money being paid. I think if you look around at the different regulations globally, and I think if you picked the best aspects from those, and I know India is looking at different aspects overseas legislation. I think ultimately not something that works in the United States might not work here. And that's important to recognize, and very often that's forgotten in the United States and it's forgotten elsewhere in the United Kingdom, for example. And being able to put it into a local context is very important.
So your views on what the regulators need to do or what they're already doing, or their point of view.
As far as the bounty which is given or proposed in the Dodd-Frank Act, if I were to take the cognizance of Siemens, in Siemens we have a policy that a whistleblower, it's an employee's duty to blow a whistle if he sees something wrong, so he doesn't get paid for it. It's a very clear message. It's a part of our duty as an obligation as an individual, as an employer-employee relationship. You don't get paid for it.
It's like a fundamental duty.
It's a fundamental duty to report wrongdoings. That's the bottom line.
Yeah, so I think regulator is one aspect of it, but the bounty is the other aspect of it. Just to give you a small and a very interesting anecdote, Ranbaxy was fined about 500 million for using bad manufacturing facilities, and the whistleblower is an Indian who actually got 48 million as reward, right? That's a huge incentive for whistleblowers to sort of get their act together, right? It's almost like getting a retirement at the age of 40, and actually maybe more. Now, talking about regulators, regulators in the West, especially in the States, have been always active, right? They generate revenue out of regulators there. India, while we do not generate revenue out of it, but there are a few factors why we see an increased enthusiasm among regulators. One, their strength have been increased. Right. Infrastructure has increased manifold. As I just said, CBI, one floor in an old dilapidated building to a one full building, right? You have cyber cell wings in almost every state, probably in multiple districts wherever there's more business. Another example, Augusta Westland Finmeccanica was actually a scam which was being investigated by Italian agencies. It was not in India that it started. When the Indian agencies, CBI, got the wind of it, they actually reached out to the Italian agencies and asked for all documents and papers so that they could start it. This was possibly one of the few times the CBI really took on an exercise like that completely suo motu. So despite the fact that Indian regulators do not generate revenue for the governments, I think there's obviously some push from the current disposition at the center to sort of keep a check on corruption. I think with more staff, more awareness, and some new legislations, the regulators are getting really enthusiastic, and they are actually cooperating with investigators and prosecutors across the world. So they are also in some kind of a race to show that we are also very good, we are also very prompt. So that's something that corporate India or MNCs have clearly recognized, and at times it is often argued is misguided, is motivated, but whatever it is there.
So, but that brings me to the point that this sounds more like a reactive, arrangement than being proactive. Do the regulators have enough surveillance in place or surveillance mechanisms in place? Any views on that?
No. So, and that would possibly the same across jurisdictions. Speaking specifically for India, they don't do surveillance unless they are tipped off or they have been instructed to do so. They are not proactive agencies. They are essentially.
There is work to be done in that.
I think at this point in time, the investigators have their hands full, right? Definitely, you can go ahead and create surveillance mechanism across the country, but my guess is that there will be too much work. You will see policemen all around the country, and that probably means a lot of work for us. So, I would surely hope so.
Anuj, to add to that, we leave out the CVC. The CVC also plays a major role in government organizations. So now that acts as more of a deterrence. Right. Then CBI comes first, so that they can hand over the cases to the CBI after they do the preliminary investigations. Right. So the CVC, at least it's relegated only to the government circles. But when they bring in a place, they do a bit of surveillance, they do a bit of proactive vigilance mechanism in place. So to an extent, it's creeping in, even in government organizations. But to add to what Shashank said, I fully endorse his views. We have still some miles to go on this.
So, yeah,
I'd
please.
just like to add one point on the whistleblower policy. I think there is still a little bit of weakness on the legal side because if it's a public sector organization and you get a complaint which is anonymous, then you cannot take that into account. You can't take any action based on that. It has to be by name, but then there's no protection for the whistleblowers. So I think that weakness needs to be addressed if we want this policy to become
Correct.
robust and functional.
But in different ways, Brinda, you've also interacted with government, regulators or government bodies, and you would have a view of the different regulatory bodies as well. Do you think there is enough synergy or there's enough cooperation, for example, between the CBC or the CBI and things like that, or there is still a bureaucracy, or there are some obstacles still there that need to be, overcome?
To some extent, there will always be some turf war. Everyone would want to control their turf, but I think there's a great level of cooperation and coordination between the regulatory agencies. There was a time when the people were talking about a turf war between SEBI and RBI, whether these products are they market-related products or are they banking products? So there was some, but I think those have been sorted out. That will happen as we go on and as business evolves. But I'm sure the regulators have enough maturity to settle these issues. So I think there's enough cooperation between all the regulatory agencies. At least from the financial sector, is what I can say.
Brings us to the next important point of discussion, and that is assessment of controls, and that is where Neville, you would have the best view, being an internal compliance chief, and how do you feel that internal controls are enough? Whether periodic assessment is being done enough? Your views on that?
So, periodic assessment is important, and we can categorize some of the controls as which are daily controls, quarterly, half-yearly or annual controls, depending upon the volumes and depending upon the risks. Now, once you put this in place, you need to ensure that they are working. Now, you need an assessment. So, when you do an assessment, who does this assessment and how qualified is that assessor, which is important. In Siemens, we have a RIC department, a Risk and Internal Controls, which does the assessment of some of the control requirements. We have also bifurcated some of these controls as compliance-related framework requirements, where compliance steps in, does a quarterly like a quasi-audit.
Right.
Over and above, we have an internal audit.
Right.
And then to cap it, we have the statutory audits. So there are a lot of reviews and audits which are done in a phased manner to ensure that the control mechanisms work. Now, in spite of them, if you have a throw-up, then it's important that we identify the loophole from where that's emanated, so that controls can be reinforced.
Right.
So, if you do all this, then you have a robust control mechanism in place, which we would call it in not a compliance or an internal audit, but you call it ICS, Internal Control Systems, which is the mother of all controls.
Right.
This is how we would like to put it across.
So, Brinda and Andy, you both touched upon the human angle, not just the controls, but all the human angle and the management signals and where the management needs to make this a critical management function. So, any further views on, how these controls could be better put in place, and about, the monitoring and checking their reliability?
Okay, first of all, I think the board needs to be very clean and the board needs to be above board. It must be seen to be someone who is very strict about this whole compliance issue and about ethics. Beyond that, I think then comes the top management, the key personnel. Like for example, recently the Infosys issue where there was excessive payment to one of the key management personnel. So things like this would create disruption. So the board itself should be very clear and clean, the top management, and of course this whole culture should be passed through the whole organization through training, as Neville has emphasized in what they do in his organization. So through training, through conversations, and making sure that everybody understands that this is the only way to go forward, not just an option.
Andy, how about your thoughts, and especially, how do your views on how do the domestic firms compare with international firms as far as internal controls and their periodic assessment, And then Shankh, of course, we'll need your views as well.
Sure. Again, I think it comes down to the discussion we had earlier in terms of the sectors involved, the amount of resources which are available, and also just culture. But obviously, I think controls come in different forms. There is the periodic assessments, daily, weekly, monthly, but then there are the ad hoc assessments as well. And employees should be encouraged that if they see an issue, to call it out and not just wait or ignore it. And particularly where companies are entering into new industries, new jurisdictions, or indeed there are new regulations or new laws. Encouraging employees to interact, both those on, at the coalface, but also those within in terms of financial controls, etc. And possibly rewarding those employees where they have shown improvements in place and perhaps caused significant savings for the company.
Sure.
Yeah, so control and assessment has typically or relatively been much more robust in MNCs. But actually the experience that we now have among Indian corporates is, again, shifting and huge amount of stress on controls and assessment. There are situations where in a manufacturing and a sales company you've seen or we've seen regular assessment and upgradation of their ERP systems, right? Which often is the source of siphoning of funds, wrong recordings of profit, sales, etc. data, essentially to get better incentive at various managerial levels. We've seen all of that. We've also seen a huge number of companies which are actually, and that's where general counsels and compliance counsels role comes in. We've seen a large number of Indian corporates actually looking out for corporate or ethics compliance officers from MNCs. What these Indian companies are trying to do is trying to get the international experience of these companies by way of the International Compliance Council, so that they can institute these procedures in the Indian companies, right? And that's a huge shift. And I think, and that also sort of marks the importance of legal and compliance council in India. So while to start with it was very different, but slowly and steadily I think even Indian companies are getting aligned to the structures and mechanisms for control and assessment. I think the big and the more important factor here is a more ethically organized, profit-driven, corporatized MNC or even an Indian company. We can see a huge shift in culture. Unless the promoters or the managers or the top management have a cultural view of this issue, nothing will change, right? You can have officers, you can have systems, but if at the top there's no commitment to following the systems and intolerance to these issues, we are not going to achieve, but that's changed and visibly.
It's a very heartening point that you brought out about the change of culture, and everybody I think agrees to that. But that we've generally covered all the topics that are related to economic crime and how we can fight it internally. But it brings us to the last aspect of it. What is the way forward? What do the panelists see the role of each of these stakeholders that we spoke about, and including the external stakeholders, regulators, and so on and so forth. So I'd like to have your holistic view on the way forward as such. So I'll start with Andy. Andy, your thoughts, please.
I think things are becoming ever more complex. The workload of GCs is increasing and will continue to increase. But I think also what we've seen is the growth of the compliance officer, who didn't exist X number of years ago and now has increasing power at the board level, for example. Also other types of officers such as chief information security officers and the like. And I think that will certainly continue. I think overall the advances of technology are going to both help and perhaps hinder. Some companies will be taking advantage of data analytics to perhaps look at front-end identification of fraud, which will also increase the workload of GCs, compliance, internal audit, etc. So I think the future, I think, is brighter,
Right.
but I think it's going to be busier.
Okay. That's not a bad problem to have, actually. So, Brinda, how about you?
I would completely agree. Yes, the future is definitely brighter, and but at the same time, there is no one size fits all.
Correct.
So we will have to look at whether just because it's applied in an MNC abroad, can we do the same thing for Indian companies? We'll have to tweak it a little bit, as happened in the financial sector. I'm talking from there, the capital requirements, for example. So we will see economic crime. That's not going to go away anyway, but we need to be also be better prepared to tackle this through a whole range, starting of course from ethics. And I think ethics will have to become the center point of any company, of any organization. And there's need for a big transformation in the culture of every company. And I think that's the only way to fight this menace of economic crime, which is not going to go away anywhere, by the way.
Shankh.
Yeah, so I can only echo both their thoughts, but let's understand how this works. Economies, corporates, they all grow, more investment, more money, which only means more incentive for wrongdoers to do wrong, right? And that's the learning from history. And it's the long understood principle and doctrine of law that law will only follow crime. Law will never be ahead of crime. So a small example, 15 years ago, SEBI regulations were a handful. If you look at it now, SEBI manual actually is 2 big volumes, which essentially is regulating the securities market. And I can actually see the same thing in India happening. We now have a bill proposed, which is proposed an act similar to the FCPA, which is more actually in the lines of the UKBA. There's a Whistleblower Protection Act, which is coming out with substantive amendments. The old Prevention of Corruption Act will have substantive amendments to include private individuals to be guilty if found abating offences, which is not the case at this time.
That's the UKBA part of it, right?
No, even the Prevention of Corruption Act today only penalizes government officers who take bribes.
Right.
The only way you can get a private individual involved is that he was a part of the conspiracy and abated into that crime.
Right.
Now the Prevention of Corruption Act will actually bring within its ambit an individual, private individual who's participating in that crime. So that's the big shift that the law is looking at. Again, FCPA, UKBA, Whistleblower Protection Act. We've seen a huge number of changes in the Companies Act, which actually brings about a huge amount of control and somewhat disclosure requirements for such actions. Now, in the Western countries, we've seen there's a huge culture and reward for disclosure, for self-disclosure. I think that's one big shift that Indian companies should be prepared for. There will be a reward for disclosure very soon, and there'll be a huge penalty for non-disclosure, which actually will be equated to participation in an offense, right? So, economy growing, more investment, more crime, more laws, more complex laws, and great time for lawyers.
Your thoughts?
Do I need to add?
Or any other thoughts?
No,
over
but,
above?
but I would like
We are
to
already short of time, actually.
Yes,
So,
that's a common thought to what has already been addressed over here. It's going to be busier times, but as he said, we need to catch up with the criminals to deter him from committing a crime rather than then following it through.
Right.
Yeah, that's the end
Right.
of it.
Well, thanks for your views. I think the messages that I've taken from this panel discussion is that firstly, economic crime is growing, it is not going anywhere. But the good part is that companies, regulators across the globe are doing much more to prevent and fight this menace. But the third part is, however, there's always a however, there's a part of it which is still unknown. Like as technology advances, cyber threats become more and more complex. Artificial intelligence takes over. Are we better prepared for that? And I'm sure that would be a bigger topic of discussions 2 years down the line when that becomes a much more prominent issue. With that, I think we've finished. I think we may have a couple of minutes for questions. If anybody has any questions, you can direct it to the panelists.
I think they have more thoughts than questions. Getting prepared.
I think then the panelists have done a very good job. No questions, actually. Thank you so much. Pleasure being here. Thank you, panelists. Thank you.
Thank you.
Thank you, Anuj, for moderating this panel discussion. And I think tackling economic crimes internally or externally is something which will continue to be a challenge. And then, as Shankh actually mentioned, law just follows, and it looks as though the criminals are one step ahead all the time. And we never know when we will be at least in step. Forget about overtaking them or anticipating. Thank you very much. It has been an excellent discussion, and various aspects have been covered. Thank you, Anuj. Thank you, Andrew. Thank you, Shankh. Thank you, Neville. And thank you, Brinda, for that very insightful perspectives as an independent director. Thank you very much.